right. These guys kind of need no introduction, but I'll do it simultaneously since they're both named Paul. These are the Pauls from Paramount Settlement Planning and Precision Lien Resolution. They sort of need no introduction because Andrew already kind of did it and explained how useful they are and what they do. And if that wasn't enough of an explanation, the next half an hour of them answering all of your questions surely will be. So I'm just going to turn it over to you guys to dive into this Q&A or give a little, intro or whatever you want to do. You good to go?
I'm pretty sure we can just dive into it. It's some of the folks have been on for an hour and a half now. So rather than talk about us and what we do, we resolve liens, we settle cases, we help manage the end of case, prepare clients for life after litigation, all of those things. And with that said, let's get to your questions. Paul Loudenslager has been with me now for 10 years. He's the chief counsel for Precision Lien Resolution. So if anybody knows it in the world, Paul's out there litigating cases in the states of Washington and Kentucky, and is getting all kinds of wonderful, let's call it experience. Yes, okay. So I don't see the questions, however.
No worries. I can read them out to you, or maybe okay, Paul great. Can. Yeah, Paul, can you see them?
Yeah, I can see them. I think there's a few in here that are from Andrew's presentation, but looks like first lien question. If a judge attributes all of a settlement to an infant for future damages, can CMS still go after the parent plaintiff for past medical payments?
So we're talking about a case with a parent. So if it's CMS, would have a parent who is a Medicare beneficiary, and then a child who has incidental benefits paid for by Medicare? Is that the situation, I'm assuming? Paul, what would you say there?
That seems to be the case. So if you have a case with an infant, it's very rare that CMS is going to be involved. That said, if the parent is also a plaintiff and is a Medicare beneficiary, and the parent has not been injured in the case or has not been subject to any physical injury for which Medicare would have paid any medical expenses, then there would be no obligation with respect to CMS for the parent plaintiff. Going to the issue of a state court judge's allocation of damages, though, Paul, that's a question we get all the time.
Yeah, not going to work, folks. He just, CMS not being a party to that release, okay, is not going to accept a release that doesn't properly allocate. Now, that doesn't mean it can't happen. It doesn't mean that there can't be a hearing and a judge determine in an adversarial proceeding that all of the payment is for future medicals, or all of the payment is for past pain and suffering. And I think one of the better tips on these kind of cases is, if you know that you're going to have a limited recovery anytime that you have CMS involvement, and I learned this many years ago before I even started the company, it doesn't make any sense if you have a limited policy or limited coverage to sue for past medical expenses when your pain and suffering is far in excess of what you can recover. We've reviewed a case that Michael Hayes, J. Michael Hayes, a Buffalo attorney, very prominent Buffalo attorney, litigated all the way up through the CMS channels, where he had an arbitration decision, and in the actual bill of particulars in the case, there were no, in the case proper, there were no claim for past medicals. He put no past medicals in the arbitration decision, and ultimately the arbitrator gave him no past medicals. He thought that was proof positive that he was not getting compensated for past medicals, and therefore Medicare would not have a lien. He took that all the way up through the administrative processes, and at one point the intermediary reviewer what's it called, Paul? The second step of the appeal process agreed with him and said, okay, you're right. You didn't sue for medical. You didn't recover medical. We're giving you your money back. And then unilaterally, a couple months later, reversed themselves and unfortunately had to go up and spend almost 2 years litigating this case up through the channels. Ultimately, the judicial hearing officer, what do you call that, Paul? The
Administrative law judge.
administrative law judge in that case, and I can send you the case. I'll redact it, but send it to you. But the administrative law judge said, yeah, you're right. You didn't sue, but you didn't specifically disclaim past medicals in your summons and complaint. A ridiculous presumption, a ridiculous assertion. But because of that, you owe the money. Your client owes the money. So yeah, it was a crazy case. But just to show you that the power that they have to not only ignore an allocation and a release, but they also oftentimes can ignore an allocation in an adjudicated hearing by arbitration. Now, we have a lot of success with those, but that's just one example. Sorry to go on that, but that's a very important issue. Next question.
Okay. For a plaintiff in an auto accident that receives extended no-fault benefits, is there a lien or subrogation claim the plaintiff may have to pay back?
Yes, there's if you're talking about a lien or subrogation claim associated with the extended benefits paid by the no-fault carrier, in my view, the answer is no. However, they do have a claim against the third-party defendant directly. The nature of APIP is in the nature of subrogation only. There's a Court of Appeals case from, I believe, 2009 called Allstate versus Stein, and that really defines their subrogation right. There is no direct right to go after a plaintiff who is recovering the money. It's a subrogation right. Practically speaking, however, if you settle the case without consulting the APIP carrier, you are cutting off all future benefits. So be careful about that. It's a very fine line to walk. You have to get, we can talk about that in a whole nother seminar. If you want to call me directly, you can. I can give you examples. But there is no direct claim. It's a claim against the defendant. As a practical matter, it may keep the case from being settled, because if the defendant knows they have to pay this claim, they might want to reduce your payment by that amount. So next question, Paul. Oh, let me get to one really important. Listen, if you have any of you have clients that have not been injured yet who are motorcyclists, tell them to purchase whatever kind of insurance that they can for their injuries. We have a case every single day where a client who was a union carpenter or a teamster is driving, they're now in their mid-50s, they got their nice Harley, they're driving down the road, someone cuts in front of them, they have $100,000 and $200,000 worth of injuries, and they're getting paid from their medical benefits are being paid from the union fund, which is a self-funded ERISA plan, which has very strong recovery rights. And usually the person that cut in front of them has a $100,000 policy. So now we're facing that situation where, you've got $250,000 worth of lienable medicals and a very limited policy. Yeah. If you can encourage people before they have the accident, which means before they come to you, to get insurance on that, any kind of public broadcast would be helpful. Go ahead, Paul.
Okay, is there usually a percentage that Medicare, Medicaid, or comp will take off the lien after the settlement? That depends on the type of lien it is. Medicare, for example, must reduce by the same ratio of attorney fees and expenses to the gross settlement. So if you got a third fee and some expenses that makes up 35% of your total settlement, Medicare must, by regulation, reduce its claim by 35%. That's the reason why you request the final demand letter from Medicare. You put the settlement amount, you put the attorney fees and expenses there, because Medicare will make that calculation and demand a lesser amount on the final demand letter. Comp will usually reduce for attorney fees
And expenses.
Medicaid, sorry?
Yeah, the cost of expenses as well, same thing, right?
Medicaid is not usually the case. Now, Medicaid is interesting because of how it's handled. Most notably, if you're downstate, you may be working with New York City Human Resources Administration. If you're in one of the upstate counties, you might be working with HMS, the private company that the state has contracted with to handle their Medicaid liens. Or some states have opted out of the HMS deal and are still handling it themselves. And they all may take different approaches to resolving these things. But for Medicaid generally, there is no hard and fast rule that they must reduce for the cost of litigation like there is with, Medicare. But it's important to remember that Medicaid liens are more limited by the U.S. Supreme Court's decision in Alborn, in that they are only able to put a lien on the amount of the settlement that represents compensation for past medical expenses.
Oh, there's some challenge to this Medicaid's limit to just past medical expenses nationally now, right?
Right. There was an 11th Circuit case recently from Florida that decided that not only is Medicaid entitled to lien the past medical component of the case, but also the future medical component of the case. So if you've got somebody that's going to be treating and there's a big future medical component to the case, that greatly increases the Medicaid agency's ability to, lien potentially 100% of what has already been paid. That has just been granted cert by the Supreme Court. So that ought to be a question that is going to impact us potentially greatly, but hopefully we'll be sticking to the past medical component, which
I mean, if they follow precedent, that's what they should do. On the other hand, we've always found in litigating these Medicaid cases that the courts really like to protect the public fisc, F-I-S-C, the short, they like to protect the pot. So be very interesting to see what happens on that case. Go ahead, Paul.
Okay. When does a Medicare or Medicaid lien get triggered? The answer to that is there's no obligation to repay until such time as there is a settlement. But we always say as early as possible, as soon as you sign up the client and know that Medicare or Medicaid is involved, you can get that process going, know the potential exposure before, number one, it could be one of these upside down situations where it's a limited policy and Medicare or Medicaid has paid more than what the policy limits are, in which case you've got to do the lien resolution before you actually settle the case. Or, just for the purposes of obviously knowing the potential exposure to your client and the ultimate net that they're going to get from the settlement.
That's a really important part about what Andrew has said since the first chapter of his 7-month process is communications with the client. There's nothing worse, and we're in this situation once again, probably daily, right? Where I had a Medicare conditional payment from a year ago, and it was $5,000, and we settled the case for $100,000, and now it turns out that the Medicare lien is $150,000. Look, if one of the things that we do in our office is to make sure that that doesn't happen by making sure that all proper charges are on that. It sounds counterintuitive, but we want to make sure that all the proper charges are on there so that we can at least know, so the client can know, so he's not the attorney's not going to experience an irate client who thought they were going to get $60,000 and finds out now that they're not going to get anything. And it does happen daily because folks do almost a good job of tracking Medicare and Medicaid. Dangerous situation to be in. You don't want to be there. and the client is really irritable because we've experienced it with attorneys. The client is really irritable after they were expecting X and find out that they're getting zero or maybe zero. So, and that really puts us in a very difficult position because every day that client's calling the attorney doesn't want to call us, but he has to call us because he has to tell the client that he called us. And it takes a long time to get these kind of upside down cases resolved. Don't do it. One of the benefits of getting in early, and I see that question on the side here, when do you get it? It's never too early to get involved. You're obligated to do this particularly with the statutory liens. I have always lectured that with Medicaid, there's no lien unless they've properly filed. But, served and filed their lien. The flip side of that is, what happens if you've negotiated and you're almost ready to close the case and then they file and now you have a problem? So you decide which way you want to go on that. But we always think that you need to find out from your clients what type of medicals they're on, who's paying their medical bills, and check and follow up with them once a year, because with Medicare, clients can leave every October. They have the right to switch to a different plan, a Medicare Advantage plan. And then they can come back to Medicare the following year. So you got to track them every year. Every February is a good starting point. Check and see who's paying their medical bills. So, Paul, another question?
Right. So, to that end, it can be difficult to track these types of coverages. There's a question in here about, sometimes when the client is deceased, it can and can't help determine what types of coverage that are out there. The best way to do that is probably with requesting billing records with the medical records to see who is paying for all those for all that medical treatment. Really, the only situation in which there is not a lien period is if no fault is paying all of the bills, or if your client has just a regular health insurance policy, either, if it's a small employer and they have a plan that's funded with health insurance, that is triggered by the general obligations law, which says no health insurer shall have a right of reimbursement or subrogation in any case that settles in the state of New York. That's really the only situation where you don't have a lien issue.
Or big government plans. I mean, a lot of them are still paying for private insurance as opposed to being self-funded.
Right, but it may take sometimes a great deal of investigative work to figure out, okay, who was actually paying the bills and what kind of plan was it, and what are their rights actually. It's a difficult situation sometimes, but it is something that we're here to help with at any point.
A couple of good questions I want to get to real quick. Be careful. This is a point that I want to get out. Be very careful about a case that you were handling where you're seeking recovery for a bed sore, and you're hoping to get a couple $100,000 on that case, and the medicals are probably $10,000-$15,000 related to that bed sore. Client's on Medicaid. The client dies before you resolve the case, and now all of a sudden there is a claim against the estate for a separate claim. It is not technically a Medicaid lien. It is a claim against the estate, and in those situations, all of a sudden now the state can go back, or the social services agency can go back to the last 10 years of all medical care and service provided. So now all of a sudden you have cases that you would have had maybe a $15,000, $20,000, or $50,000 manageable lien that all of a sudden now has gone to hundreds of thousands of dollars or even $1 million, depending on how long the person's been institutionalized. Be very careful. Those are very difficult, no exceptions to them. That also goes to the question about deceased client. But a couple of interesting questions over here, Paul, and I'll let you read some later again. What do you do when the settlement is confidential, but the third-party lien holders want to know the settlement amount before reducing their liens, before they'll discuss reducing their liens? First of all, if the settlement is confidential, I think you'll probably get consent in most cases from the defendants who think there might be exposure to them in the event of, if it's a Medicare, certainly, if it's a Medicare Advantage plan, certainly, if it's a Medicaid lien, arguably, they could be exposed to, the defendant's carrier could be exposed to that coverage, even though you've already settled the case. Many cases out there where Medicare Advantage plans have gone after a defendant's insurance company after the fact and successfully collected double damages even after they paid out the settlement. So you'll usually get cooperation, I think, in that case as an exception. Try to build that into your confidentiality language is the best thing that I could tell you to do, and indicate that you only discuss those parts of the settlement. They don't really need to know who the defendant is. They might only need to know how much it's settled for. So there are ways to handle that.
And I see that now a lot in the confidentiality clauses where it'll specifically have communication with lien holders for the purposes of, resolving liens as an exception to the confidentiality provision.
Speaking of confidentiality, Andrew touched upon it a little bit earlier, as did one of the participants in the program. I mean, I think that everyone needs to know that personal injury, pain, and suffering is tax-free. Payments for confidentiality are always taxable. The question is, when you add confidentiality language to a personal injury settlement, you're giving, the problem is, I should say, you're giving the IRS an opportunity, not that this happens every day, but you're giving the IRS an opportunity to review the case and make a determination as to what portion of it was really paid for confidentiality. For instance, if you use language, and I'm putting my settlement planning hat on now because we draft numerous releases every week and review numerous releases every week, and we're very careful about the confidentiality language. If you put language in there that's very extreme, like, all right, that the confidentiality is a material part of this settlement, and any breach thereof will allow the defendants to recover the entire amount of the settlement. Well, there you have set it up so that the settlement is taxable, even though we know that that wasn't the case, but it would be a good argument for the IRS to make. Some of the things that we try to do, we're really good at mitigating that confidentiality language to make sure that it's meaningful, yet it's not taxable. So so on that point, I'll move from that and go back to the lien questions, Paul. When does an ERISA lien arise? Hopefully never in your cases, but unfortunately. So ERISA, just generally, and Paul is an ERISA specialist, but ERISA, remember this, anything that you get, any benefit you get related to work is ERISA, but that doesn't make it automatically lienable. So for instance, if I have a small business and I get my health insurance and I pay premiums for my employees through the Chamber of Commerce, and it's pure insurance, they accept my premium in exchange for their risk at covering everything. No reimbursement in New York, but it's still ERISA. But it's the self-funded ERISA plans. Your client works at a big bank, has 1,000 employees, or a big corporation has 100, 200, 300, 400 employees. It's cheaper for them to self-fund. And those, the Supreme Court has said repeatedly that the language in their plans, even though your client never read the plan, is enforceable against your client. So you need to know how your client's medical bills are being paid. So research it, make sure you find out how they're being paid, who your client works for, and if they're a big plan, be prepared to have a lien issue. What happens if there was a lien that wasn't taken care of? Well, if you have a Medicare Advantage plan and you didn't pay it back, and it's hard to track Medicare Advantage plans because they don't send you letters. They do track trauma well. They're pretty good at tracking trauma, but they're not a public entity. They may have some lag time. They don't have direct access to the client's files a lot of time, and so they may not track you for a while, and the client settles the case. If they do that, in many jurisdictions in the United States, there's claims against the attorneys for double damages. There have been some claims made against the attorneys for double damages in New York, in the federal courts, and in Connecticut. Those largely have been unsuccessful in New York, but in jurisdictions like Virginia and Florida, absolutely double damages against the attorneys who haven't paid that lien, and absolutely double damages against the carrier who already paid out the settlement on that lien. Any other situations, Paul, you can think of? Medicare,
Medicare, yeah. And it's a complicated situation because especially with Medicare and Medicare Advantage, because the attorney is subject to direct liability. And a lot of the times the defendant or defendant's carrier is subject to an action after a settlement for failure to repay or address a reimbursement claim, which, of course, puts you and your client in a bad spot when they come back with that release that probably includes an indemnification and hold harmless provision for any lien issues.
Yeah. So if that defendant's carrier has to pay out, he's coming back under that indemnification, hold harmless. The next, I see one there. Question, I think, is it a good idea to contact CMS relative to ask if they intend to assert a Medicare lien? Always ask CMS on Medicare. They're honest, right? And continue to ask them all the way up every 90 days. In our office, what's the follow-up period, Paul? How often do you send an inquiry? So
every 90 days. Yep.
Every 90 days. So our office will handle a lot of these liens for many firms across the country. And our policy is with Medicare, take it out of your office, give it to us, and we'll make sure that this problem doesn't happen. And every 90 days we follow up. And if the client has a surgery that's not on that bill, you're not going to get away with it. Okay, because at the end of the case, you're going to send in your final settlement detail statement, and they're going to do their final research. And that's why we have so many of these surprise Medicaid demands, because people think naturally, hey, we might escape this, or they don't follow up enough to make sure that Medicare is tracking correctly. And then at the end of the case, they get a surprise lien. We make sure that doesn't happen. It doesn't mean we're not going to challenge the charge later or immediately after it's put on. But after the case settles, okay, you have one shot. Now you have to go up through the administrative appeals process. And it's like case I talked about earlier with my case, it took years to get up there. It's not so much anymore, but it's still a long period of time when your client's waiting with no money. During the case, as we do frequently, as soon as every 90 days, they see an improper charge, they attempt to remove it right away. It gives us it's a much better position to be in. Paul, anything else there you see you want to address?
How much can a Medicaid recipient receive without losing benefits?
Depends. It depends on the type of Medicaid that they're on. There are multiple types of benefits. Again, putting on my settlement planning hat real quick, Mark, this will be my last one. Anybody can email me directly, but this is really important. So there's different kinds of Medicaid. So there's two different kinds since the Affordable Care Act was passed, Magi Medicaid and traditional Medicaid. And all of this is affected by SSI. If a client is on SSI, supplemental security income, they're only allowed to have $2,000 in assets if it's not protected by a supplemental needs trust or a pooled trust. Next, if they are just working poor, okay, and they are not disabled, they might have Magi Medicaid, and that Magi Medicaid allows them to have a $500,000 in a kitty, as long as that $500,000 doesn't generate over 17 or 18, I think the number is maybe even $19,000 a year now for an individual in income. It's only income tested. And that is a beautiful thing, because structured settlements do not count toward that income test, as opposed to other investments that will, including even tax-free municipal bonds are modified, adjusted gross income. They're added back in. So structured settlements can be invaluable there relative to assets. So if they're on the traditional kind of Medicaid, SSI is $2,000 is all they're allowed to have. If they're not on SSI and they're on the traditional Medicaid for the blind, disabled, and they're on traditional Medicaid, it would be around 15,900 that they're allowed to have. And there are strategies for that. And then if they're on Magi Medicaid, they're entitled to have an unlimited amount in their pot, as long as their income doesn't get triggered, which is why we use structured settlements there. One good question I think
Sure.
Paul should try to answer. It's frequently comes up. What happens when a plaintiff who should never have used no fault to pay for medical instead used her Medicaid, or should have used no fault, instead paid for her Medicaid? Is there any way to force the carrier to respond to the Medicaid lien out of the 50 limit of PIP benefits? And we've seen that a lot. It's very, it's probably best for a no fault attorney to answer, but we do know that there are limits on this. Paul, you want to touch on that real quick?
Yeah, so there's no way to force them, but there are two potential ways to address it. Number one is, if there's money left on the no fault policy, it's not exhausted yet, and you've got a lien here, or Medicare or Medicaid or whatever, that clearly should have been paid for by no fault. In many cases, you may be able to convince the carrier to just pay that lien directly and have it be part of the 50,000. You can't force them to pay it, but a lot of times they will just agree to pay it. The other way you have to do it is directly challenge it with Medicare or Medicaid, and show them the no fault information, give them the ledger, show them that there's money left available, that these things should not have been paid for by Medicare or Medicaid. And a lot of the times either will just drop those charges from the lien obligation as if you were disputing them as not related.
Yeah, just importantly, I think Medicare is better at that, because all they have to do is point the finger to the no fault carrier. The no fault carrier has to respond. Am I correct, Paul?
Right. Well, yeah, that's another issue, but generally, yes.
Okay. Frank, someone just settled a bodily injury case with a client who is Medicare eligible but still has private health as primary. What documents do I need to provide Medicare to get a payout letter? So, which you expect to be zero. So the documents are always the same. The documents you can get from CMS's website. But be careful. The reason I called this question out is because be careful, because most private plans will have a coordination benefits clause. In fact, I've never seen a private plan that didn't have a coordination of benefits clause. And that coordination of benefits clause, and Paul can probably quote it, but it basically said is if your client becomes Medicare eligible, once the participant becomes Medicare eligible, this plan becomes secondary. Am I right, Paul?
Right. Well, it depends what kind of plan it is. There are
Sure.
different rules. If it's a small plan, less than 100 employers or participants, over 100, depends on, if it's a federal employee plan, who provides the coverage, et cetera, and so on. But if you type in just in Google Medicare, who pays first, it'll give you a PDF that shows all the different kinds of coverages and the rules as to who pays primary versus secondary.
All right. So if you have a retired city worker, they'll pay for the Blues, will pay for whatever Medicare doesn't cover. So it all depends on the plan. Good, Paul. Anything else you see there, Paul, that's exciting? They're all exciting, but we don't want to keep everybody here all day. Multi-defendant, okay, let's see. What about a situation which plaintiff is considering accepting a small, less than 10K settlement with only one defendant, a multi-defendant tort case, but wants to know if accepting a settlement cause a lien to be taken on his Medicaid and or state benefits. In other words, he couldn't take the settlement if a lien would be imposed. Is there a way to get an answer in advance from New York State before accepting the settlements? Yeah, I mean, but it's hard and it's not quick. I mean, generally the time to determine if you're not on notification as to a Medicaid lien, Paul, how long does it generally take for you and your very, very efficient team to get a Medicaid lien printout?
Well, there are two ways to get a printout. Depends on who you're working with. So if it's HRA downstate, since the pandemic, they've been very slow. You're talking at least 60 days to get a number from them. HMS is a lot quicker. The individual counties that do it themselves are a lot quicker. But if you're looking for just the medical expenses that have been paid by Medicaid that not necessarily are related, but a list of all the medical expenses, period. You can get that from the State Department of Health pretty quickly.
Thanks, Paul.
I want to thank the Pauls so much for this Ask Me Anything question session anyway. And we do have plans for 2 more CLEs with the Pauls. We've got one planned for October that's focused on taxation, and we have one planned for December focused on liens specifically. So we will spend lots more time delving into those topics in a more organized way, and both of those will also have Q&As after as well. So don't worry, plenty of time to get all of your burning questions answered. So thanks so much, Pauls. I appreciate it. Appreciate your time and expertise.
Very good. Thank you
Thank you.
very much for the opportunity, and thank everyone. Sorry we couldn't get to all the questions in a half hour, but we will try our best to get.
Awesome.